Welcome. I'm Mark Hammond, South Carolina Secretary of State. Thank you for your interest in becoming a notary public in the state of South Carolina, or for your continued service as a notary public. As a notary public, you hold an important position in South Carolina, serving the public as an impartial witness and performing a variety of official acts to deter fraud related to the signing of important documents. This webinar is provided to you to help you understand the duties of a notary and the trust which has been placed in you as a public official. Once commissioned as a notary public, it is the responsibility of the notary public to maintain a level of education appropriate for conducting their duties. I encourage you to attend our yearly workshops to remain informed on current issues affecting notaries. This webinar is designed to provide an overview of the duties of the notary. For additional information, please visit our website at www.sos.sc.gov.
I am Allison Dempsey from the South Carolina Secretary of State's office. In this webinar, we are going to review the process to become a notary public, as well as the duties and restrictions placed on notaries public. In order to become a notary public in the state of South Carolina, you must complete and submit an application. The application is available on the Secretary of State's website at www.sos.sc.gov. The same application is used for both renewals and new notary applications. There are 3 qualifications requiring in order to become a South Carolina notary public. An applicant must be a registered voter in this state, must be able to read and write the English language, and must submit an application containing no significant misstatement or omissions of fact. The application form must be provided by the Secretary of State's office and must be signed with a pen and ink. The signature must be acknowledged as the applicant's by a person who is authorized to administer oaths. South Carolina does not require notaries to be bonded. In addition, South Carolina law does not require notaries to maintain a journal of their notarial acts, though it is strongly encouraged. An example of a notary journal is included in your materials. To complete the application, you will first need to complete the top part of the first page. Please make sure you put your voter registration number on the application. If you do not know your voter registration number, you can go to the State Election Commission's website at www.scvotes.org to obtain this information. Make sure you do not sign this application until you are in front of a notary. The notary date and your signature date on the application must match. It is very important that you sign your application the same way that you plan to sign when you notarize documents. This is the way you will be commissioned and should also match your notary seal. For example, if your full name is John James Doe, but you print and sign the application as John Doe, you will be commissioned as John Doe. When you complete the application, you will mail it to your county legislative delegation. If your county is not listed on the application, you will mail it to the House of Representatives. The contact information you will need can be found on page 3 of the notary application. It can take anywhere from 2 to 12 weeks to process new or renewal applications. It depends on how quickly the county legislative delegation is able to review the application and forward them to our office. Therefore, if you are renewing, please send in your application 8 to 12 weeks before your commission expires. And remember, you cannot notarize any documents if your commission has expired. Often, when you become a notary, you will receive mailings and other information from notary associations or groups outside of the Secretary of State's office. Please remember that membership in these groups is optional and that completing and filing the notary public application with the county legislative delegation and the Secretary of State's office is the only way to be commissioned as a South Carolina notary. You cannot become a South Carolina notary online or at any other website. Your notary commission lasts for 10 years. After you receive your notary commission, you have 15 days to file your notary commission in the Clerk of Court's office. You will file in the county where you live and are registered to vote. The fee is $5. There is a notary search engine on our website. You can search a notary by name and/or county to see if a person has been commissioned and when a notary's term expires. After becoming a notary public, you have an address change, name change, or need a duplicate commission, you will need to file the Change of Status Duplicate Commission Request form. This form must be filed within 45 days after one of these changes. As with your original application, the way you sign your new name on this form is the way you will be commissioned and should match the way you notarize documents. There is a $10 fee for this form. Please make sure you do not change the way you notarize documents until the name change is filed with the Secretary of State's office and your new updated commission is received. If you want to resign your notary commission, you will need to file the Change in Status Resignation form. There is no fee for this form. Under South Carolina law, notaries public may perform various types of notarizations. Notaries public are public officials in the state of South Carolina. Notaries serve as impartial witnesses to the signing of documents in order to prevent fraud. As a South Carolina notary public, you can perform various notarial acts, including acknowledgments, oaths, affirmations, attestations, jurats, signature witnessing, verifications, and any other acts authorized by law. There are complete definitions as well as examples in the Notary Reference Manual. As a South Carolina notary public, you can only notarize documents while physically in the state of South Carolina. If someone brings you a document from another state or country, you can notarize the document so long as the person signing appears before you in South Carolina to execute the document. A notary's seal must have the notary's name as commissioned and the words Notary Public and State of South Carolina. You can use the embosser seal or the ink seal. When notarizing a document, your notarial act must be attested by the signature of the notary exactly as shown on the notary's commission, the legible appearance of the notary's name exactly as shown on the commission, and the statement of the date that the notary's commission expires. The notary should also sign in ink. However, a lack of seal or expiration date does not invalidate a notarization so long as the official title is included. Make sure that the document presented contains notarial language such as sworn and subscribed before me, with the space for your notarization. A notary with a disability may use a signature stamp upon prior approval by the Secretary of State's office. A notary public can charge up to $5 per notarial act. If you plan to charge a fee, you must conspicuously display your fee schedule. A notary public is permitted to charge travel fees so long as the travel fees are agreed upon by the notary and requesting party in advance, and the notary must clearly explain to the requesting party that the travel fee is separate from the notarial fee and is not specified or mandated by law. As a notary public, you have certain duties that you must adhere to each time you perform a notarization. When a person requests a notarization, that person signing the document must be in the notary's presence at the time the notarial act is performed. Prior to notarizing a document, a notary must verify the signer's identity if the signer is not personally known by the notary. If the signer is not personally known by the notary, he or she will have to provide satisfactory evidence of his or her identity. Satisfactory evidence means current identification document, oath of credible witnesses known to the notary, oath of 2 witnesses who each present a current identification document. Current identification document means a document issued by a state or federal agency that includes a photographic image of the individual's face, an image of the individual's signature, and a physical description of the individual, or a current passport without a physical description of the individual. By performing a notarial act, a notary public certifies in his or her judgment the signer did not appear to be incompetent, lacking in understanding of the nature and consequences of the transaction requiring the notarial act, or acting involuntary, under duress, or under undue influence. South Carolina law provides procedures for when a person requires the services of a notary public but cannot physically sign a document or can only sign using a mark. There are 3 different ways to do this. First, when asked to notarize a document for a person who can only sign by using a mark, the mark must be made in the notary's presence. Below the mark, the notary should write, "Mark affixed by," name of the signer by mark, in the presence of the undersigned notary. The notary then notarizes the signature by mark. Second, if the principal cannot sign at all and directs another person to sign on his or her behalf, the principal would direct the designee to sign in the presence of the notary and 2 witnesses. The designee signs the principal's name in front of the notary and witnesses, and the witnesses sign their names near the principal's signature. The notary writes below the principal's signature, "Signature affixed by, designee in presence of," names of principal and witnesses. The notary then notarizes the signature. Third, if the principal cannot sign at all, he or she can direct the notary to sign on his or her behalf. In this case, the principal would direct the notary to sign the record in the presence of 2 witnesses. The notary signs the principal's name in the presence of the principal and witnesses, and both witnesses sign their names near the principal's signature. The notary writes below the principal's signature, "Signature affixed by the notary at the direction of," name of principal, and also in the presence of, names of witnesses. The notary then notarizes the signature. In addition to naming various functions that notaries public perform, South Carolina law sets forth several limitations on notaries public. You must never notarize your own signature. Do not certify copies of documents. The holder of the document can complete an affidavit which may then be notarized. There are examples of this in the Notary Reference Manual. Do not notarize incomplete or blank documents. Do not notarize a document without using notarial certificate wording. For example, a jurat statement with the words, "Sworn and subscribed before me." Do not notarize for a subscribing witness when the witness is not in your presence. Do not postdate or predate notarizations. Do not notarize outside the state of South Carolina as a South Carolina notary. Do not notarize a document if you are a signer of, a party to, or a beneficiary of the document being notarized. There are limited exceptions to this prohibition for court employees as well as notaries that are not parties to the document and are named in the document as a person to whom the document will be sent to after recording, a trustee in a deed of trust, a drafter of the document, or an attorney for a party to the document. Do not notarize a document where you will directly receive a commission, fee, interest, or other consideration exceeding permissible fees for notarial acts. There are limited exceptions to this prohibition for fees or other considerations paid for services rendered to licensed attorneys, licensed real estate brokers or salespersons, motor vehicle dealers, and bankers. There are additional restrictions on a notary's use of foreign languages. Notaries public cannot use the term notario publico or its non-English equivalent in any advertisement or notice. If you are a notary public who is not an attorney and advertise your services in another language, you must include the following notice in English and in the foreign language in which you are advertising. I am not an attorney licensed to practice law in the state of South Carolina, and I cannot give legal advice or accept fees for legal advice. In addition to the restrictions we've reviewed, South Carolina law governing notaries public also lists several actions that are illegal for notaries public to perform. The Notary Act provides a list of actions that may result in a misdemeanor conviction. A person who commits any of these acts is guilty of a misdemeanor and subject to a fine up to $500 or imprisonment of up to 30 days or both. These misdemeanors involve performing a notarial act when a principal or subscribing witness has not appeared in person before the notary, performing a notarial act without personal knowledge or satisfactory evidence of identity, performing a notarial act if the notary knows that it's false or fraudulent, holding oneself out to be a notary without a notary commission, performing a notarial act if your commission is expired or has been suspended or restricted, performing a notarial act before taking the oath of office, performing a notarial act with the knowledge that you are not a notary public, using, concealing, defacing, or destroying a notary seal, or knowingly soliciting, coercing, or materially influencing a notary to commit official misconduct. Notaries public are barred from providing any sort of legal advice or from answering legal questions. Specifically, unless you are a member of the South Carolina Bar or otherwise authorized to perform prescribed legal activities by action of the South Carolina Supreme Court, you are prohibited from the practice of law. This includes preparation of legal documents, giving legal advice, or answering legal questions, appearing in court on behalf of someone else, performing a real estate or mortgage closing, and conducting of a title search and preparation of title documents. If you perform any of these activities, you are involved in the unauthorized practice of law. If found guilty of this felony, a person may serve up to 5 years in prison and be fined up to $5,000 per offense. For more information on the unauthorized practice of law, please refer to the South Carolina Bar's website. In addition to providing commissions to notaries public in South Carolina, the Secretary of State's office is the office that can authenticate documents to be sent to another country, including documents that have been notarized by a South Carolina notary public. The Secretary of State's office provides a certificate or an apostille that is attached to the document. In order for the office of the Secretary of State to authenticate a document, it must be signed by an official whose signature is on file with the Secretary of State's office, which includes notaries public. Some examples of documents that are brought in for authentications are vital records, school transcripts, and international papers. The apostille or certificate provided by the Secretary of State's office certifies that the public official is in fact a public official capable of signing in his or her capacity. Many of the documents submitted for authentication are notarized documents for which the notary is the public official whose signature is authenticated. If you are notarizing a document to be sent overseas, please include your seal, expiration date, and print your name as commissioned clearly near your signature if your name is not included on your seal. The country receiving the document might reject it if the notarization was not properly executed. Please keep in mind that as a notary, you cannot certify photocopies of documents. The person who is the holder of a document can execute an affidavit or written statement stating that the photocopy is a true copy of the original document. The holder of the document could have a notary notarize the written statement. This can be done for documents such as school transcripts, diplomas, and passports. In addition, notaries cannot certify vital records. Only country, state, or county officials have the authority to certify copies of vital records such as birth certificates, marriage licenses, or death certificates. The Secretary of State's office cannot authenticate affidavits executed for copies of documents when a certified copy can be obtained from an official source such as vital records or background checks. Thank you for your interest in learning more about being a South Carolina notary public. If you have any questions, you may contact our office. For additional information, please refer to the South Carolina Code of Laws, Title 26, Chapter 1, in the South Carolina Notary Reference Manual.